friends, welcome to the world of Companies Act 2013. I, Professor Kunal Shah, is over here on behalf of JK Shah classes to present you all the revisionary part of Companies Act 2013. Yes, my dear friends, in this revision lectures, we are going to cover the amendments which are been given under revisionary test papers which has been applicable for the students who are going to give their exams in the month of December 2021. Over here, till now, we have completed the revisionary part of chapter number 1, that was the preliminary part, wherein we have completed the revision of about characteristics of a company. We also revised a topic called as lifting of a corporate will, and yes, we also had a revision about various types of companies. Now, in this video, we are going to revise the next chapter of Companies Act 2013, and that chapter is chapter number 2, called as Incorporation of a company and matters incidental thereto. Over here, this entire chapter is been covered under chapter number 2 of Companies Act 2013, wherein chapter number 2 comprises of section number 3 up to section number 22. So the list of sections which gets covered in chapter number 2 is from section number 3 up to section number 22. Yes, my dear friends, the very first topic we are going to revise over here is a topic towards promoter of a company. The very first topic we are going to revise over here is about the promoter of a company. Whenever I talk about promoter, so yes, promoter is a person who conceives the idea of doing a business in a form of a company. Once the idea gets conceived, it is the promoter who brings the company into existence. It is the promoter who forms the company by completing the procedure for incorporation of a company, which is given under section number 7 of Companies Act 2013. Yes, Memorandum of Association and Articles of Association, both of these documents are considered to be the fundamental document for a company. Without this document, a company cannot get incorporated. So whether you talk about Memorandum of Association or whether you talk about Articles of Association, both of them, yes, both of them are fundamental documents. It is the promoter who shall prepare MOA and AOA. Generally, the directors in a company are being appointed by the members of the company. Generally, the directors in a company are being appointed by the members of the company. But the first directors of the company are being appointed by the promoters of the company. It is the promoter who enters into preliminary contracts. What do you mean by preliminary contracts? So preliminary contracts are those contracts which are being entered before the company came into existence. They are the contracts which were being entered before the company got incorporated. It is the promoter who enters into such preliminary contracts on behalf of the company. Over here, when I say promoter, so yes, promoter is a person who is really interested into the business of the company. It is the promoter who is really interested into the business of the company. The word promoter is been defined under section number 2, clause 69. The word promoter is been defined under section number 2, clause 69. The definition of the word promoter is having a word called as means, which means that the definition is of exhaustive in nature. The definition is of exhaustive in nature. See, there are 3 points given over here. If we are able to satisfy any one of the given condition, if we are able to satisfy any one of the given condition, then yes, you are considered to be called as a promoter of the company. No, we are not over here to fulfill all the 3 conditions. In fact, we need to fulfill any one of the given condition. The lawmaker over here says that promoter is a person whose name is given inside the prospectus of a company as such. If inside the prospectus of a company your name is given as a promoter, so yes, you are the promoter of that company. Or else your name has been identified as a promoter inside the annual return which has been filed by the company to the ROC on year-to-year basis. Either you are a person who have got a control over the affairs of the company. Such control can either be direct or it can even be an indirect control. So whenever you have got a direct control over the affairs of the company, or you have got an indirect control over the affairs of the company, in any of the situation, you are considered to be the promoter of the company. The lawmaker over here says that promoter also means a person in whose advice or in whose direction or in whose instruction the board of directors of the company are accustomed to act. If the board of directors of the company are been working as per your advice, if the board of directors of the company are been working as per your direction or as per your instruction, so yes, you are considered to be the promoter of that company. But one thing should be noted over here. If you have given a direction under a professional capacity, then sorry to say, you won't be considered as a promoter. Generally, if the board of directors are working as per your advice, as per your direction, as per your instruction, so you are considered as the promoter of the company. However, if you have given the directions under professional capacity, then sorry to say bro, you are not to be considered as the promoter of that company. See, for example, I am an auditor, and as an auditor, under my professional capacity, I have given some instructions to the board of directors. And yes, the board of directors are following my instructions, so that does not mean that I will be considered as the auditor of that company. No, because board of directors are listening to my instruction, they are working as per my instruction, but I had given those instructions under a professional capacity. So yes, my dear friends, we have understood the meaning of the word promoter, and we have also understood the definition of the word called as promoter. Let us move on towards the next topic of this chapter, that is Memorandum of Association. But before starting with Memorandum of Association, there is one more topic over here called as Incorporation of a company. There's a huge procedure given inside your JKS's textbook which talks about the procedure for incorporation of a company. Yes, my dear friends, that entire procedure is been covered under section number 7 of Companies Act 2013. Is it mandatory to incorporate a company? The answer is yes. And whenever we need to incorporate our company, we need to fulfill the provisions given under section number 7 of Companies Act 2013. There are total 8 steps given, wherein step number 1 up to step number 5 will be considered as a pre-incorporation procedure. It is on step number 6 the company comes into existence, and it is on step number 7 and step number 8 we have got the post-incorporation procedure. However, that entire procedure we have already covered during our regular lectures. That entire procedure we have already covered during our regular lectures. So now let us move on towards the next concept of this chapter, one of the lengthiest concept in this chapter, that is Memorandum of Association. Yes, my dear friends, the word Memorandum of Association tells us that it is a charter for a company. Memorandum of Association is a charter for the company. See, to run a country, we require a constitution. In a similar way, to run a company, we require Memorandum of Association. Memorandum of Association defines the contractual capacity of the company. In fact, Memorandum of Association also tells us about the various objects the company can undertake. So whenever we talk about Memorandum of Association, so it is one of the fundamental documents without which a company cannot get incorporated. Over here, what is the reason for a company to have Memorandum of Association? The very first object to have a Memorandum of Association is that it will help us to identify the possible scope of operations beyond which the company cannot go. It will define the scope of activities for the company. What a company can do, is been defined inside a document called as Memorandum of Association. Yes, my dear friends, Memorandum of Association will enable the shareholders as well as creditors and all those who deal with the company to know what are the powers and what are the activities the company can undertake. Yes, under section number 399 of Companies Act 2013, it was already been said that Memorandum of Association is a public document. Any person who is going to enter a contract with the company will be assumed to have the knowledge about this document. So it is the duty of an outsider, to have the knowledge about the contents of the MOA. You have the knowledge, that's best. If you don't have the knowledge, then sorry, it will be presumed that you are having the knowledge about the contents given inside the Memorandum of Association of the company with whom you are going to enter a contract. Memorandum of Association will also help to the shareholders, wherein the shareholders will come to know that their money will be utilized for what all purposes by the company. The money which the shareholders have invested inside the company, the money which the shareholders have invested inside the company will be utilized for what all activities will be written inside the Memorandum of Association. The lawmaker over here says that a company can never ever go beyond the provisions of Memorandum of Association. Whenever a company tries to do an activity which is beyond the purview of MOA, then such activity is not to be considered as valid. However, it will be considered to be void in nature. It will be considered to be void in nature. Sir, by which ways the company can form Memorandum of Association? Yes, whenever a company wants to form a Memorandum of Association, it will be formed as per the provision of Schedule 1 of Companies Act 2013. Yes, I've already told you guys that in Companies Act 2013, there are total 7 schedules, out of which Schedule number 1 will be utilized for the preparation, for the formation of Memorandum of Association. Schedule 1 comprises of 10 tables. Schedule 1 comprises of 10 tables, wherein the first 5 tables, that is Table A, Table B, Table C, Table D and Table E. These are the first 5 tables which will be utilized for the formation of Memorandum of Association. So, can we choose any table as per our own choice? The answer is no. You cannot choose the table as per your own choice. You need to choose the table. You need to choose the table depending upon the type of company you are. If you are a company limited by shares, then yes, the memorandum of your company will be formed as per Table A. If you are a company limited by guarantee having no share capital, then the memorandum of your company will be formed as per Table B. If you are a company limited by guarantee having share capital, then yes, yours memorandum will be prepared as per Table C. Table D is for the companies having unlimited liability, having no share capital. Whereas Table E is for a company having unlimited liability, having share capital. Whenever a company has formed a Memorandum of Association, then yes, Memorandum of Association should be in a printed form. Every content should be divided into different paragraphs. It should be numbered consecutively. It should be consecutively numbered. Yes, the memorandum requires to be signed by at least 7 persons in case of a public company. However, if it is a private company, then at least 2. If it is a one-person company, then at least 1. Whosoever signs the Memorandum of Association will be considered as the subscriber of Memorandum of Association. Before incorporation, they are considered as the subscribers of MOA. But once the company gets incorporated, so they will be considered as the first members of the company. Whosoever subscribes the memorandum, that signature will be witnessed by at least one of the person. One of the person will be coming into the picture acting as a witness, and that person will be witnessing the signatures of the people who have subscribed the MOA. The lawmaker over here says that the details of the subscribers of the MOA, will also be given inside the MOA. Over here, once the company has been incorporated, so that company will be acting as a legal person. In the eyes of law, company will be considered as a person. However, it won't be considered as a natural person. It will be considered as an artificial person. If you are a minor, then sorry to say, you are not allowed to be acting as a subscriber of the MOA, because a minor is not competent to enter into a contract. The guardian of a minor who subscribes the MOA on behalf of the minor will be assumed that the guardian has himself subscribed the MOA. It will be assumed that the guardian has himself subscribed the MOA. Whenever we are going to form the Memorandum of Association, always and always remember, Memorandum of Association can never ever go against the provisions of Companies Act. Memorandum of Association can never ever go against the provisions of Companies Act. So what are the information? Sir, what are the contents inside the memorandum? The very first content inside the memorandum will be about the name clause. The second one will be the situation clause, also called as register office clause. The third clause inside the memorandum is the object clause. The fourth clause is the liability clause. The fifth one is the capital. The sixth one is the association clause, also called as subscription clause, and the last one will be the succession clause, and this clause is possible only and only in case of a company called as one person company, in case of a company called as one person company. So yes, my dear friends, we are going to revise the contents of these 7 clauses, and whenever we want to alter them, we are also going to revise the procedure for the alterations. So the very first clause inside the MOA of a company, the very first clause inside the MOA of a company is the name clause. Inside this name clause, we have to just write down the name of our company which we had reserved. The name which was been reserved shall be written inside the name clause. Whenever you talk about the name of the company, always and always remember, the name of the company shall not be identical with the name of an existing company. If today I want to name my company as Reliance Industries Limited, then sorry, it is not allowed. Because the name of a company cannot be identical with the name of an existing company. Identical names are not allowed. In fact, nearly resembling names are also not allowed. What do you mean by nearly resembling? The name should not be very near to the name of an existing company as well. In fact, if the name of your company is undesirable in the opinion of the central government, then sorry to say, your company cannot even have such names which are undesirable in the opinion of central government. You cannot have the name of your company which is acting as an offense under any law. If the name is acting as an offense under any law, sorry, such names are not allowed. The lawmaker over here says the company is not allowed to even have a misleading name. The company is not also allowed to have a misleading name. In fact, if you are going to use a word or an expression inside the name of your company which is suggesting a connection with a state government or a central government, then you are allowed to use such words or expressions, but only after getting the previous approval from central government. Only after getting the previous approval from central government. Whenever your company wants to use some special words inside the name of your company, special words means a word called as commission, authority, undertaking, national, union, central, federal, republic, president. If any of such words your company is having a desire to use inside the name of your company, then yes, you need to get a previous approval of central government. You need to get a previous approval of central government. However, if you want to use the words called as insurance or bank or stock exchange or venture capital, etc., then in that case your company needs to give a declaration stating that whatever are the requirements mandated by the respective regulator. In case of insurance, the respective regulator is IRDA. For banks, it is RBI. For stock exchange, it is SEBI. So whatever are the requirements which are being mandated by the respective regulator, such requirements have been followed. Such kind of a declaration should be given. Then only you can utilize such words called as insurance, bank, stock exchange, etc. inside the name of your company. Sir, what is the procedure to reserve the name of our company? So, in order to reserve the name of your company, you need to file a form called as E-Form RUN, and RUN stands for Reserve Unique Name. Inside this form, we can propose maximum 6 names, and whatever is our proposal, it should be in a preferential order. It should be in a preferential order. The lawmaker over here says that once you have given some choices to the ROC, and if the name is available and you want to keep the name of your company which is available, then such name will be reserved by the ROC for a period of 20 days. However, if you are already an existing company and you have applied for change of name, then whatever is the new name you have chosen, and if that name is available, then such name will be reserved for a period of 60 days. So, in case of a newly getting company incorporated, the name will be reserved for 20 days. However, if the company is already an incorporated one and going for a change of name, then in such case, the name will be reserved for a period of 60 days. In this 20 days or 60 days, if the procedure is not been completed, then whatever is the name reserved shall be lapsed automatically. Lawmaker says that whatever is the name getting reserved can be cancelled if it has been proved that the company had furnished some wrong information or incorrect information to the ROC for getting the name reserved. However, the information were wrong but the company is not yet incorporated, then whatever is the reserved name, it will be cancelled, and the person who had given such wrong information will be punished to a penalty of rupees 1 lakh. But if the company has got incorporated and later on ROC comes to know that the name was been reserved through a fraudulent way by giving some false information, then ROC will give an opportunity of being heard to the company. After that, ROC can pass any one of the given order. Either the ROC will ask the company to go for change of name within a period of 3 months after passing an ordinary resolution, or else ROC can ask the company that you have given us a wrong information and we would like to strike off your name from the register of companies, or else it can also be asked to go for winding up. The next provision is section number 13, which is actually about alteration to MOA. It is actually about alteration to MOA. See, whenever a company wants to go for change of name, alteration of name will result into alteration to MOA. Alteration of name will result into alteration to MOA. The lawmaker over here says that whenever the company wants to change its name, the company is required to pass a special resolution. Along with it, the company also requires to get the approval from central government. However, whenever we are applying to the central government for change of name, the powers are being delegated to ROC. However, if you are just going to add the word called as private, or you are going to delete the word called as private from the name of your company, then in that case you don't require to get the approval from central government. The day when the company had passed a special resolution, from that day on or before 30 days, the company should file a form called as MGT 14 with ROC. See, MGT 14 is always and always required, and we have understood this thing under section number 117 of Companies Act 2013. Whenever a company passes special resolution, then yes, the company is bound to file MGT 14 with ROC within 30 days of passing special resolution. Over here, the company will apply for a new name, and if the respective procedure has been completed and later on we have made the alterations inside the memorandum, then ROC will issue us a fresh certificate of incorporation. This fresh certificate of incorporation indicates that the new name is now been effective. The new name is now been effective. Over here, the lawmaker says that there can also be a situation called as rectification of name. There are two scenarios under rectification of name. See, if the name of my company is either identical or nearly resembling with the name of your company, and your company was already been existing, then in that case, central government can suo motu, that is at its own motion, give the directions to my company, asking my company to get the name rectified, because the name of my company is either identical or it is nearly resembling with the name of your company. The moment central government gives the order upon my company to rectify the name, then yes, my company shall change the name within a period of 3 months by passing an ordinary resolution. So in scenario 1, it was the central government who at its own motion, that is suo motu, was asking my company to get the name changed. But under scenario number 2, your company will approach to the central government and raise a complaint against my company. Your company will approach to the central government and tell to central government that the name of your company is being used by another company which is either identical or it is nearly resembling. Later on, central government will ask my company to go for rectification of name. And yes, in this case, my company shall change the name within a period of 6 months by passing an ordinary resolution. But always remember, your company can raise a complaint against my company only within 3 years from the date of incorporation of my company, or within 3 years from the change of name of my company. Once we have received the order from central government for rectification of name, then we shall obtain a new name and we shall communicate this thing to ROC within 15 days by filing the order of central government. Over here, we will have to make necessary changes and ROC will issue us a new certificate of incorporation. If any of the provisions of this section is being contravened, then the company will be asked to pay a penalty of ₹1,000 for each day during which the default continues. Every officer who is in default will be asked to pay a penalty which will be minimum 5,000, maximum 1 lakh. Minimum 5,000, maximum 1 lakh. I repeat, minimum 5,000, maximum 1 lakh. So yes, my dear friends, we have completed the very first clause inside the Memorandum of Association, that was the name clause. Now let us move on ahead towards the second clause inside the MOA, that is the situation clause, which is also called as a registered office clause. Situation clause, that is also called as registered office clause. Yes, my dear friends, inside this clause, we have to just write down the name of the state. We have to just write down the name of the state where the registered office of the company is going to be situated. No, we don't require to give the exact address of the registered office. We are not required to give the exact address of the registered office. We have to just give the name of the state where the registered office of the company will be situated. Sir, is it mandatory for a company to have a registered office? Yes. See, before incorporation, it was optional to have a registered office. But once the company is been incorporated, then yes, from on and from 30th day of incorporation. On and from 30th day of incorporation, the company shall have a registered office. The company shall have a registered office. In fact, within 30 days of incorporation, in fact, within 30 days of incorporation, the company shall get its registered office verified. Sir, how to get the registered office verified? For that, we need to file a form called as INC 22. INC 22 is a form through which the company will be verifying its registered office address. Sir, but how to verify the registered office address? The lawmaker over here says that if the premises are being purchased, then we need to submit the copy of buying and selling agreement. However, if we have taken some premises on rental basis, then we need to submit the copy of the rent agreement, that is the notarized copy of the lease agreement with the ROC. However, if we are just using someone's premises as the registered office of our company, then in that case, we need to take the authority letter from the owner of that premises or the authority letter from the occupant of that premises, and that authority letter we need to submit it to the ROC. So over here, either we need to submit the copy of buying selling agreement or the notarized copy of the lease agreement, or we need to submit the copy of authority letter signed by the owner or the occupant of that premises. Along with this document, we also need to submit something called as, the proof of address. What do you mean by proof of address? So over here we need to submit is the copy of utility services. See, in that premises there might be some kind of electricity getting used or water connection or gas connection. So we need to submit the copy of utility services bill, which should not be older than 2 months. Okay. Sir, if the company wants to shift its registered office, within the same state, is it allowed? The lawmaker says yes, whenever a company wants to shift its registered office within the same state, yes, it is allowed. Wherein there are three different options. The very first option says that the company wants to shift its registered office within the local limits of the same city or the same town. So if the company wants to shift its registered office within the same local town or within the same local city, then in that case the company is required to pass a board resolution. Only after passing a board resolution, the company can shift to the new premises. Yes, the new premises should be verified with the ROC under a form called as INC 22 within 30 days of such shifting. The lawmaker over here says that if the company is going to shift its registered office within the local limits, then in that case it will not result into alteration of Memorandum of Association. See, that's so pretty obvious now, because inside Memorandum of Association we have to just write down the name of the state. And if we are shifting our registered office from one place to another place within the same local limits, within the same local city, then in that case it is not going to alter our Memorandum of Association. In fact, in all the given three situations, all the three given situations, the company will be shifting its registered office, but such shifting will be done within the same state. So in these three situations, the company is not required to go for alteration of Memorandum of Association. The second provision over here says that the company wants to shift its registered office from one city to another city, same state and under the jurisdiction of same ROC. The company wants to shift its registered office from one city to another city, same state and under the jurisdiction of same ROC. Whenever a company wants to shift its registered office from one city to another city but same state and under the jurisdiction of same ROC, then in that case the company is required to pass a special resolution. The company is required to pass a special resolution. If it is a private company, then it is required to pass a special resolution through a general meeting. But if it is a public company, then it is required to pass a special resolution through postal ballots. What is postal ballots? It is given under section number 110 of Companies Act 2013. Section number 110 is been covered under chapter number 7 of Companies Act 2013. Yes, my dear friends, whenever a company is going to pass a special resolution, the same thing will be intimated to ROC under a form called as MGT 14, and such things should be intimated within 30 days of passing special resolution. Such things should be intimated to the ROC within 30 days by filing a form called as MGT 14. Now the company will be shifting its registered office from one city to another city. The moment the company gets shifted its registered office from one city to another city, the new premises should be verified with the ROC through a form called as INC 22, and such verification should be done within 30 days of shifting. Even in this case, the company is not required to alter its Memorandum of Association. The third situation over here says that the company wants to shift its registered office from one city to another city, same state but under the jurisdiction of different ROC. One city to another city, same state but under the jurisdiction of different ROC. See, this will be possible only and only in the state of Maharashtra and in the state of Tamil Nadu, because these are the only two states, wherein we have got two offices of ROC. In Maharashtra, we have got at a place called as Mumbai and a place called as Pune. Whereas in a state called as Tamil Nadu, we have got the registered office at a place called as Chennai as well as at a place called as Coimbatore. So whenever a company wants to shift its registered office from one city to another city, same state and under the jurisdiction of different ROC, then this is possible only and only in the state of Maharashtra and in the state of Tamil Nadu, for which the company is required to pass a special resolution. The company will have to apply to the regional director. The regional director will give its approval maximum within 30 days. The approval of regional director will be filed by the company to ROCs within 60 days, and both the ROCs will certify such changes within 30 days. Over here, the day when the company had passed a special resolution, from that day within 30 days, we need to file a form called as MGT 14 with ROC. Over here, the company will shift its registered office, and now within 30 days of shifting, the company will have to get the new address verified with the ROC under a form called as INC 22. Even in this case, there is no alteration of Memorandum of Association. But yes, this is possible only and only in case of Maharashtra and Tamil Nadu, because they are the only two states wherein we have got two offices of ROC. Going back to the second provision, which says that the company wants to shift its registered office from one state to another state. The company wants to shift its registered office from one state to another state. Yes, whenever the company is going to shift its registered office from one state to another state, it is going to involve something called as alteration to Memorandum of Association. It is going to involve alteration of Memorandum of Association. Over here, the company is required to pass a special resolution. The company is required to make an application to central government. Central government will communicate its approval maximum within 60 days from the date of receipt of application. So the day when central government receives the application, from that day maximum within 60 days central government shall give an approval. But before giving the approval, central government will make sure that whether the company has got the consent of its creditors, debenture holders, and any other person who are being concerned with such changes. However, if the people are not giving their consent, then they are called as dissenting creditors. Then such dissenting creditors can either be discharged, or else the company will make them secured, The lawmaker over here says that once the approval is been received from central government, then yes, the company can shift its registered office from one state to another state, for which the company will now require to alter its Memorandum of Association. Over here, the company once alters the Memorandum of Association, now the copy of altered MOA along with the copy of central government's approval, shall be filed with the ROC of both the states. That is the previous place where the company was having its registered office, as well as at the new place where the company is going to shift its registered office. Over here, once the company has filed the necessary documents, over here the new ROC will issue the new certificate of incorporation to the company, indicating about the alterations being done. The day when special resolution was passed, within 30 days of passing special resolution, don't forget to file MGT 14 with the ROC. The new address should be verified by the new ROC through a form called as INC 22. The new address will be verified by the new ROC under a form called as INC 22. Sir, can a state government oppose a company from shifting its registered office from one state to another state, stating the reason that the state will be facing a loss of revenue? Lawmaker says no, a state government cannot oppose a company for shifting its registered office from one state to another state, giving a reason that we will be having a loss of revenue. No. If your state will be having a loss of revenue, then another state where the company is going to shift its registered office will be having something called as a gain of revenue. So as a country as a whole, there is no such change. Yes, but the employees union can oppose the company from shifting its registered office from one state to another state. This will happen when the company has got majority of employees engaged at the registered office, and now if the company is planning to shift that registered office from one state to another state, then yes, the employee union may oppose a company to shift its registered office from one state to another state. Whenever a company is going to shift its registered office from one state to another state, then yes, it will involve alteration of Memorandum of Association. So yes, my dear friends, we have successfully revised the second clause inside the Memorandum of Association, that was the situation clause, also called as registered office clause. Let us move on towards the third clause, that is the object clause. See, object clause defines the various objects for which the company was being incorporated. In fact, object clause will also determine the contractual capacity of a company. Inside the object clause, it has been clearly stated that what a company can do. The lawmaker over here says that the subscribers of the MOA, enjoy almost unrestricted freedom to choose the objects of the company. You can choose any objects for your company you want to choose. But the only restriction is that the object should not be illegal and the object should not be against the provisions of Companies Act 2013. So inside the object clause, we will come across about the reasons for which the company got incorporated. The reasons under which the company came into existence, what a company can do will be defined inside object clause of the Memorandum of Association. Now in future, whenever the company wants to alter its object clause, then in that case, the company is required to pass a special resolution. However, if it is a private company, then the special resolution will be passed through a general meeting. But if it is a public company, then special resolution will be passed through a postal ballot. So whenever a company wants to alter its object clause, the company is required to pass a special resolution. Pass the special resolution, make the alterations inside the object clause. Pass the special resolution and make the alterations inside the object clause. Now, the day when the object clause was being altered, the day when the special resolution was being passed, from that day, within 30 days, the company needs to file MGT 14 along with the altered copy of MOA with the ROC. ROC will now certify such alterations. And only when the alterations are certified, then only it will be effective in nature. So over here, we have understood what is an object clause and how the company can alter its object clause. Yes, my dear friends, the next clause, that is the fourth clause inside the Memorandum of Association, is the liability clause. Inside the liability clause, we have to just write down about the liability of the members of the company. Yes, the liability of the members of the company would either be limited by shares or limited by guarantee, or it will be having an unlimited liability. Over here, if the company is limited by shares, then yes, the provisions of section number 2, clause 22 will come into picture, which says that the liability of the members of such a company is limited and it is only and only up to the unpaid value of shares. However, if the shares are fully paid up, then there is no liability. But if the company is limited by guarantee, then the provisions of section number 2, clause 21 will come into picture. Company is limited by guarantee, then in that case, the liability of every member will be limited only and only towards the amount which is given inside the MOA as a guaranteed amount. And such amount the company will call upon from its members only when the company goes for liquidation. However, if the company has got an unlimited liability, then it is section 2, clause 92. Which says that the liability of members will be unlimited in nature. In fact, even the personal assets of the members can be held responsible to pay off the liability of its creditors, that is to pay the liability of the company. Over here, whenever we want to alter the liability clause, so the lawmaker over here says that in general, liability clause of a company cannot be altered. Yes, in general, the liability clause cannot be altered. But section number 18 of Companies Act 2013. What is section number 18? So section number 18 tells about conversion of a company. You can convert your company from one particular type to another particular type. So under section number 18, a company will be allowed to get itself converted from one class to another class, and in that case memorandum will get altered. Then in that case memorandum will get altered. But however, that procedure has been excluded from our syllabus as per the notification issued by ICAI. As per the notification issued by ICAI. Going upon the fifth clause of the Memorandum of Association, the fifth clause is the capital clause. This clause will be present inside the MOA of a company only and only when the company has got a share capital. No share capital, no capital clause. No share capital, no capital clause. Whenever we talk about the capital clause, then inside this capital clause we have to write down the details about the authorized share capital of the company. So capital clause will determine the authorized share capital of the company. However, in future, if the company wants to alter its capital clause, then section number 61, which is actually the part of chapter number 4, we are covering over here. Section number 61 says that yes, a company can alter its authorized share capital. A company can alter its authorized share capital. See, either you can increase your authorized share capital or you can decrease your authorized share capital. Whether you want to increase your authorized share capital or whether you want to decrease your authorized share capital, the very first thing you need to check whether your articles of association is allowing you to alter such things or not. If the articles of association is allowing you to alter such things, then the company is required to pass an ordinary resolution. And once the alterations are being done, then the same thing should be notified to ROC under a form called as Asset 7, and such things should be notified within 30 days of making the alteration. So there are how many ways through which we can alter our authorized share capital? So boss, there are 5 different ways. Through which you can alter your authorized share capital. The very first way says that you can increase your authorized share capital by that much amount as the company requires. If the requirement of the company is 1000 crores, then you can make your authorized share capital as 1000 crores. Or else you can consolidate your existing shares into the shares of larger denominations, which means you are going to increase the face value of your shares. Or else you can convert your fully paid shares into stock or vice versa. Or else you can go for subdivision of shares, that is you can go for conversion of your shares into a smaller denominations. Or else you can also go for diminution of share capital. See, when I say diminution of share capital, it means the authorized share capital is going to get reduced. How to reduce the authorized share capital? So we can cancel those shares which have not been yet issued by the company. So by cancelling the shares which are not been issued, which means we are cancelling something called as the unissued part, then it is called as diminution of share capital, and it should not be assumed as reduction of share capital. Yes, my dear friends, there is a difference between diminution of share capital and reduction of share capital. Diminution of share capital is given under section number 61, whereas reduction of share capital is given under section number 66. When I say diminution of share capital, then in that case it is going to affect the authorized share capital. But when I say reduction of share capital, so it is going to affect something called as the paid up capital of the company. Diminution of share capital does not affect the balance sheet, but reduction of share capital affects the balance sheet. For going for diminution of share capital, the creditors does not gets affected, but for reduction of capital, yes, the creditors gets affected. For diminution of share capital, we don't require the approval of NCLT, but for reduction of share capital, we do require the approval of NCLT. If the company is going for diminution of share capital, then the name of the company will not be ending with the words called as and reduced. But if the company is going for reduction of share capital, then yes, the name of the company will be ending with the words called as and reduced. See, in your accounts, you might have understood about a concept called as internal reconstruction. Internal reconstruction is one of the method through which the company goes for reduction of share capital. The next provision is about section number 64. However, there is a change in section number 64 through our recently issued RTP. The penalties have been changed. Previously, it was 1000 rupees per day, but now it is 500 rupees per day. However, if you are a company, then you will be asked to pay a maximum penalty of rupees 5 lakhs. But if you are an officer in default, then upon you, the maximum penalty will be of rupees 1 lakh. Whenever I talk about reduction of share capital, then reduction of share capital is given under section number 66. Reduction of share capital is going to affect the paid up capital of the company. So there are three different ways through which the company can go for reduction of capital. You can choose any one of the given method. The very first method says that we are going to convert the partly paid shares into fully paid shares. The second method is about internal reconstruction. And the third method says that we have received some excess money from our investors, so we are planning to pay off that excess money which is in excess as per the wants of the company. The money is in excess as per the wants of the company. Over here, the company is going to pay off the excess money which is not required by the company. So you can choose any one of the three methods and you can go for reduction of share capital. However, there is a procedure for reduction of share capital which we have already completed during our regular course. Yes, during our regular course, we have done a detailed study of this entire procedure along with the effects of reduction of share capital. And yes, I have also told you about the difference between diminution of share capital and reduction of share capital. Right now only, just 5 minutes back, I gave you this entire distinguish between diminution of share capital and reduction of share capital. So yes, my dear friends, we have completed our fifth clause, that was about the capital clause, which is possible only and only in case of a company having a share capital. The next clause which we are going to discuss over here is the sixth clause, called as association clause, and it is also called as subscription clause. See, any person is allowed to subscribe the MOA of a company. If you are subscribing the MOA of a company, then before incorporation, you are considered to be the subscriber of MOA. Before incorporation, you are considered to be the subscriber of MOA. But after incorporation, you will be considered as the first member of the company. So whenever we talk about the association clause or the subscription clause, then it will be having the details of the subscribers of MOA. In case of public company, at least 7% should subscribe the MOA. If it is a private company, then at least 2 people should subscribe the MOA. If it is a one-person company, then 1 person should subscribe the MOA. If the company has got share capital, then every subscriber should at least take 1 share with them. However, if you are going to take more number of shares, then that's completely allowed. That's completely allowed. Inside the subscription clause, the name of the subscriber will be given. Opposite their name, the number of shares taken by them. And yes, 1 person will be acting as a witness over here for the subscribers. The last clause inside the MOA is the succession clause. This clause you will come across only and only in case of a one-person company. You will come across only and only in case of a one-person company. Because in this clause, we have to write down the details of nominee. If the member of the OPC dies, or he becomes lunatic, or he becomes incompetent to contract, then in that case, the nominee will start acting as the member of the OPC. However, we can change the details of nominee as and when it has been required, but whenever we are going to have any kind of change in the nominee, it is not to be going to change the entire MOA. The entire procedure of MOA, that is the alteration of MOA, is not required to be followed over here in this scenario. So yes, my dear friends, we have successfully completed the entire revision about one of the lengthiest topic of this chapter, that was Memorandum of Association. So let us move on towards the next topic of this chapter, and this will be the last topic for revision, that is Articles of Association. Yes, my dear friends, whenever we talk about Articles of Association, so they are like bylaws, that is, they are like rules and regulations which governs the management of the internal affairs and the conduct of the business. In short, what a company can do will be defined inside Memorandum of Association. But how the things will be done will be defined inside Articles of Association. Articles of a company are to be considered as subordinate to that of Memorandum of Association. Yes, articles are to be considered as subordinate to that of Memorandum of Association. Articles of Association will be controlled by the Memorandum of Association. Why? Because Memorandum of Association states the objects of the company. That is what a company can do. Whereas articles will tell about how the objects should be carried out, how the things should be carried out. Over here, the word Articles of Association is defined under section number 2, clause 5. Lawmaker says articles means articles of association, which will either be originally framed or it can be altered from time to time as per the provisions of previous company law or as per this act, that is Companies Act. So whether the articles are originally framed or whether it has been altered from time to time, in the eyes of law, it is going to be considered as articles of association itself. Whenever we have to form the articles of association, then we need to take the help of schedule number 1. Schedule number 1 comprises of total 10 tables. Schedule number 1 comprises of total 10 tables. Out of which 5 tables, that is table A, B, C, D and E, was utilized for the formation of MOA. Whereas table F, table G, table H, table I and table J, these are the tables which will be utilized for the formation of articles of association. Sir, we have to choose any table as per our own choice? Lawmaker says no. You will have to select the table depending upon the type of company you are. Table number F will be selected by a company which is limited by shares. Table G is for a company limited by guarantee having share capital. Table H is for a company limited by guarantee having no share capital. Table I is for unlimited liability company having share capital, and table J is for a company having unlimited liability having no share capital. So depending upon the type of company, we have to select the respective table. Yes, inside the Articles of Association, we have got a new provision which has been introduced under Companies Act 2013, and the provision is about entrenchment provision. The concept of entrenchment provision we have already understood in our regular lectures. In fact, the concept of entrenchment provision was also there in our CA foundation. See, normally whenever we want to alter the Articles of Association, then we can alter it just by passing a special resolution. But specific provisions of articles can be altered only when some more restrictive conditions or more procedures are being followed as compared to that of special resolution. So let the company decide whether they want to have an entrenchment provision in their articles or not. If yes, then which provision should be entrenchment provision, that will be decided by the company. And those entrenched provisions can be altered not by merely passing of a special resolution, but it can be altered by having more restrictive conditions or more procedures as compared to a special resolution. Such entrenchment provisions can be introduced either at the time of incorporation of the company, or in future you can have an amendment in your articles and you can introduce the entrenchment provision. However, if you are a private company and now if you want to introduce the entrenchment provision, then you require to take the consent of all the members of your company. But if you are a public company and you want to introduce entrenchment provision, then you can give an amendment to your articles through a special resolution and you can introduce the concept of entrenchment provision in your articles of association. Over here, what is the procedure for altering the articles of association? So yes, my dear friends, in order to alter the articles of association, we need to fulfill the provisions of section number 14, which deals with alteration to articles of association. Section number 14 clearly says that whenever a company wants to alter its articles, then in that case the company is required to pass a special resolution by calling a general meeting. Pass a special resolution and alter the articles. Pass the special resolution and alter the articles. But wait, if you are a public company and you are planning to get your company converted into a private company, you are a public company and you are planning to get your company converted into a private company, then in that case you will require to add those three restrictions in your articles. You will require to add those three restrictions in your articles. Sir, which restrictions you are talking about? Oh man, we are talking about that restriction that is maximum 200 members, restricts transferability of shares, prohibits issue of securities to public at large, and prohibits acceptance of deposits from public at large. So if you are a public company and you are planning to get yourself converted into a private company, then in that case we need to add those three restrictions in our articles, for which the articles will get altered. And over here, in order to alter the articles along with special resolution, we also require to get the approval from central government. Once the articles are being altered, then such alterations we require to file with ROC. And whenever we are going to file such alterations with ROC, we also need to submit the copy of the order of central government, if any. Only when the alterations are being registered, then only the alterations will be effective in nature. So yes, my dear friends, in this chapter we have revised a topic called as promoter of a company. We had a quick revision towards a procedure about the incorporation of a company. We have done a thorough revision about Memorandum of Association, and yes, we have also revised a topic called as Articles of Association. So that's all towards the chapter called as chapter number 2, Incorporation of a company and matters incidental thereto. Thank you so much.